The short, sharp shock was used quite a bit in the latter part of the Young Offenders Act, previous to the current legislation, which is the Youth Criminal Justice Act. And we had quite a bit of evidence of courts using these short sentences of, let's say, 5, 7, 10 days to deter them away from engaging in crime. And what we found, in fact, was that it was quite ineffective. Young people are changing and developing. They are not necessarily thinking about the consequences. We want to be careful that when we respond to young people, that we are not doing more damage through the law than we are good. So the Youth Criminal Justice Act has implemented and included something called extra-judicial measures, or diversion. What diversion attempts to do is to minimize the effects of the criminal law on young people, while also at the same time making them and holding them accountable for their offenses, doing so in a way that's proportionate to the harm caused by the offense. There are two gatekeepers to diversion. There are the police, who are the first responders typically, and the police have a lot of discretion. They can respond to young people by simply giving them a warning, giving them a caution, which is a formal warning, or referring them to a program within the community. It might be that a police officer decides that the young person cannot be adequately held accountable through diversion and lays a charge. The second gatekeeper is the Crown prosecutor, who also has discretion to divert the young person away from the courtroom. And so this can be very beneficial for young people, but also for the system more broadly, because what it allows us to do is to reserve those resources for young people who have alleged to have committed more serious offenses and who go through the court process, perhaps being found guilty through proportionate responses, be it diversion or through proportionate sentences. Most young people will eventually desist, as we say, from engaging in crime.